Please consider. Test, test, test. Yep. Yep, start recording. Good afternoon, everyone.
Hola, buenas tardes a todos.
Pleasure for me to join with you today as we talk about a really important topic of copywriting. And how do we not get in trouble when it comes to images, music, uh, videos? How do we stay out of trouble? So that's what we're going to be talking about today. I have a wonderful guest that's joining us. I'm going to introduce her in a minute, but just some housekeeping items before we get going. We do offer translation for this meeting that we're going to have, this Zoom meeting that we have online. So if you see the interpretation thing down at the bottom, that's going to be up and going shortly. So just let you know that that is available, Spanish, English to Spanish translation. Hopefully my earpiece will stay in and not fight me on this thing. Well, I am Pastor Ken Dixon, and I serve as the Vice President for Communication Public Relations here at the Texas Conference. And I just want to welcome you. Thank you for taking time out of your day to join us for this important topic, especially in this time where content is being created, people are sharing, lots of things that are happening. And I'm happy to welcome my guest, attorney Jennifer Woods from the General Conference. She is serves as the General Counsel for the General Conference. And so we are so glad that you have joined us today. Welcome, welcome, welcome to Texas Conference.
Thank you.
Wait. I think.
Thank you. Can you hear
are
me?
You muted?
It says I'm not muted. Can you hear me?
Okay, everybody hears her but me.
Oh.
All right.
Well, I guess I will try start my presentation at this point.
All right. Let me Jennifer, let me let you go ahead and introduce yourself.
Okay.
And I'm going to let you go ahead and jump into your presentation. And then I'm going to work on some audio so that I can hear you, because it makes no sense for me to see you but not hear you.
That's fine. I'm going to go on and get started. Thank you for the introduction. My name is Jennifer Woods. I'm actually not the General Counsel. I'm one of the Associate General Counsels at the General Conference. We have 5 attorneys, and I handle intellectual property matters and privacy. So that's trademark and copyright, and also how to protect people's personal data. So this particular presentation I'm going to do, it's a short intro into copyright. And then hopefully we'll have some time that I can go over some questions and answer any concerns that you may have. So let me go on and share my screen, and let's go into this learning about copyright. So we're going to quickly talk about what copyright is, what it covers, how long it lasts, and then the important thing is, what is copyright infringement? How can we avoid it? What are the penalties? So copyright is a set of rights that are granted to creators of original works of authorship. And it applies as soon as a work is fixed in a tangible form of expression. These terms that are in quotes are actually directly from the US copyright statute. And so this is how how it's defined within the United States. Certain works can be copyright protected, and those works include books and other literary works or computer software programs, for example. Of course, musical works, which has its whole other host of implications. Dramatic works such as skits and screenplays, choreographed works, sculptural works and images, also motion pictures and audiovisual works where there's both something of a visual nature and an audio nature at stake. Sound recordings, and even architectural works and architectural structures can have copyright protection attached to them. However, things like facts and ideas, those don't get copyright protection. So if I am the owner of a copyright, what does that give me the right to do? Well, that gives me the right to do the following. I have the right to make copies of my work, to distribute my work, to publicly perform the work that I've created, to display my work, and also to create derivative works. So what this means is that if I created a book, then only I have the right to decide whether or not to allow someone to make copies of that book. And only I would have the right as the copyright holder to determine if someone could make translations or make changes to the work. Also, if someone were to take my book and post it online, that would be a violation because as the owner, I have the sole right of displaying my work. So copyright ownership in the US and in most countries actually applies automatically without any need for me as the copyright owner to register the work. As soon as my work is fixed in a tangible form of expression, meaning as soon as the book has been written or a song, as soon as I have created the lyrics to my music or sung a song and recorded it, then copyright protection applies. Now, in the case of employees, if I create work as an employee, for example, this copyright presentation that I'm sharing with you, I'm an employee of the General Conference. Actually, I don't own the copyright to this presentation, the GC does. So in the same way, if you're an employee of the conference or of the union and you create any kind of creative work, and you're doing it on behalf of your employer, the employer ends up being the copyright holder and copyright owner, not you, meaning that they have all of those rights. They have the right to make copies, they have the right to sell, they have the right to grant other people the rights to do these things. So what is copyright infringement? Well, copyright infringement occurs when someone uses either the entire piece of a protected work or a part of the work without first getting permission. So example, if you decide to use a song and you want to perform that song online or make a CD of the song, and you don't get permission from the creator of the song, that's copyright infringement. Or if, let's say that you have a song and you want to translate it into Spanish or into another language, you can't really do that unless you have permission if the work is still under copyright. Also, if you find images and you want to use images, those are copyright protected works. And unless you have a license to use the image or some other explicit permission to use the image, your use of the image would constitute copyright infringement. So what are the penalties of infringement? Well, under US copyright law, there are statutory damages that can go up to $150,000 per infringing work. So even just taking one little image and misusing it without permission or using it without permission could subject you to a huge penalty. And that's per infringing work. So let's say that you ended up taking 5 images instead of 1, then you're talking about statutory damages of, $750,000 that you could be liable for. Additionally, under US law, you could face prison terms if your infringement is willful, meaning that you know you're infringing and you continue to infringe. So there are some steep penalties involved in violating someone's copyright. Not every creative work, though, requires permission. Not every creative work is covered by copyright. So there are two main exceptions where you don't have to get permission before you use a creative work. The first one is work that you've created. If you create the work, then you are the copyright holder. And that means that you get the right to decide if you want to make copies or make adaptations or derivatives of the work, if you want to display the work. You have all of those permissions because you're the owner of those rights. The other big category where you don't need to get permission to use a work is for material that has entered the public domain. So under copyright law, copyright only lasts for a fixed period of time. You see, the reason for having copyright is we want to be able to incentivize creators to monetize the work that they have created. So we give them a certain length of time to monetize, to charge for use of their work. And then after that time has passed, the work enters the public domain, meaning that anyone is then free to use the work. Anyone is free to make copies, to make derivatives, to make adaptations, to display the work without having to get any permission to do so. For most countries, copyright will last for the life of the creator plus a minimum of 50 years. In the US, it's the life of the creator of the work plus 70 years. So this is for any work that was created post 1978. For the US, anything that's pre 1978, there were different laws in place. And so the length of the copyright really depends on what year it was created. The one general rule I can tell you is that currently in the US, anything that was created before 1924 has now entered the public domain. So anything that's that's 1924 or later is probably likely still covered by copyright and is not free to use without some sort of permission in place. So I want to give you a cautionary tale just to give you an example of how this comes into play. So this is a scenario that I actually see quite often. And it's that a ministry wants to make a PowerPoint. And in this case, we'll say it's for like a healthy eating seminar, a health message seminar. And they go online to find images. Let's say they're finding images of strawberries or fruits or vegetables as they talk about the importance of getting, proper nutrients into your body. And they make this presentation, they put the PowerPoint onto their ministry's website, and it's lost. I mean, no one's really looking at it. It's just on the website someplace, deeply embedded. Well, years later, what will typically happen is they'll get this letter from an attorney or from this rights management group. And it's a strongly worded letter that says, you owe us X thousands of dollars. Please cease immediately from using this image. We found it on your website. You can get a license for X thousand dollars, or we'll take you to court. This happens all of the time. And the reason it happened is because the ministry didn't do their due diligence in making sure that all of the images they wanted to use were either public domain, original works of their own, or that they had proper licenses. When this scenario occurs, usually the best I can do for them is to tell them, yes, you've infringed on this image. Let's try to negotiate a lower payment. But 9 times out of 10, there will be a payment involved, because that is a very common example of how our departments and ministries and pastors get into copyright trouble. A second area that is worth discussing is the area of music. Now, music and copyright is a very complex area just in general. It's only been become more complex now that we're in this era of COVID-19 and people worshiping from home and not worshiping together. And here's the reason. For music, you not only have copyright for the musical piece, you also have copyright for lyrics, if there are lyrics involved, and there's also a copyright for the sound recording. So let's say that there's an artist that recorded the musical piece, that's also copyright protected, and it's a separate copyright. So there are all sorts of licenses that may come into play if you want to use music, depending on how you want to use it. First, there's the master use license. And this is if you want to use the artist's recorded version of a song. And those rights are usually held by the record label. Then there's a performance rights, right? So if you want to sing a song, let's say for congregational worship, that typically under normal circumstances would require a performance rights license. And those in the US are administered by 3 performance rights organizations: BMI, ASCAP, and CSAC. Then there's a mechanical license. Let's say that your church choir wants to make a CD and then distribute the CD for ministry purposes. Well, you'll need a mechanical license to do that if the music that you're wanting to use is still covered by copyright. And then lastly, a common license that we end up having to deal with is called the synchronization license. And this license is important for whenever you want to use music with some kind of visual background. So think about if you want to show pictures of nature and have music in the background, or you want to put music as a background to your website. Well, for that, you'll need a synchronization license. And that is different than all the preceding licenses, in that you'll have to contact a number of rights holders to do that. So you may be wondering at this point, well, we don't have to get all of these licenses when we sing in church. And this is true. When you sing in church under the US copyright law, there is a specific exemption for public performance during religious service. But this only applies to in-person religious service. So when you are physically in church and singing, that's what this exemption covers. It doesn't cover online worship, which most of our churches are currently doing. That exemption doesn't apply then, and it doesn't apply to if you want to display the lyrics that your church is wanting to use onto a projector. And this is why we often recommend that churches get licenses to fill the gap. And the 2 that we recommend whenever I do this kind of presentation are CCLI license and CCS license. And I realize that for your conference, it's more than a recommendation. And I really commend that, because it protects the conference, it protects you, and it gives you some peace of mind as far as your use of music. So I think at this point, I'm actually going to stop sharing. I think that this is a good point for us to have some dialogue. So I'll open it for questions from you.
All right. You guys can hear me okay?
Yes.
All right, good. So thank you, Attorney Woods, for this overview of, oh man, I was taking some notes as you were talking. One of the things that we try to share is the ethics of doing things, and the ethics of our churches interacting with the community, and also with pieces of content or assets. And so we always want to be ethical, and when we do these things, so that we don't find ourselves in trouble. And that is, as Attorney Woods mentioned, here in Texas Conference, all of our churches, we purchase the licenses. Well, the church purchases the license, and it is part of their general liability. And the reason why it is a general liability is because just like your roof, there's insurance on your roof. There's insurance on your walls, your buildings, your pipes, and all of these different things in your church itself. We have to ensure that the digital aspect of things and the content of creation is also protected, because as she mentioned, $150,000 per infraction is not something that the conference wants to pay. We want to make sure that we minimize. Now, you may be saying that, we're not gonna do anything wrong, but I always share this with our churches, is that you may not be there forever. The pastor may move. And another pastor may come in with a different mission, different vision, and these things may apply. So we want to make sure that for our churches, it is in place. Now, I know that one of the things that we often hear is that we can sing hymns, and that's all we sing are hymns. And I know that there are several churches that's all you sing are hymns. But tell us about the hymn, the Adventist hymn book, when it comes to copyright.
Sure. So the rights that you have when you purchase the hymnal, you have the right to sing the hymns for congregational singing. Just because music is in the hymnal, it does not mean that music is within the public domain. It means that the the publisher, Review and Herald in this case, has obtained the rights necessary for them to sell the book for congregational singing. What this means is that it does not include the right for you to make recordings of certain songs, because those songs may not be copyright protected, may still be copyright protected. It does not allow you the right to make adaptations of all the songs in the hymnal, because again, the music still may be copyright protected. And as an example, I'll just list one song that many of us know, almost all of us should know. It's the song "We Have This Hope." It is kind of our unofficial Seventh-day Adventist hymn. That song is not public domain. That song is copyright protected, and it's not copyright protected by the church. It is owned by an individual, because an individual created that song on their own time. And so even at the GC, when we want to use that song, let's say that we want to make translations and display the lyrics or make a recording, I have to then reach out to the copyright holder and ask permission, and I get a license. And sometimes, depending on the use or who I'm requesting the license for, there may be a charge included, because again, we want to pay people what they deserve to be paid for the creative works that they've created. So even songs like "We Have This Hope," it doesn't mean that we're all just free to use it. No, we have the right when we buy the hymnal to sing it for congregational singing, and that's really it. There are many songs in the hymnal that are public domain. Amazing Grace is an example, but it really depends on the date the song was created. And there's information in the hymnal that kind of will give you a clue as to whether the song you want to use is public domain or not. It gives the year. And oftentimes, if we know the copyright holder, that information is at the bottom of the hymn in question.
Now, one of the other things that often comes up is our churches that get flagged on Facebook, YouTube for music. And you mentioned that, you can't use parts of a song. You can't use I'm often told, well, I'm only using 30 seconds or 10 seconds of the song. But you mentioned that you can't use parts of those songs because it's still copyrighted. But the other thing that when you mentioned was that the on YouTube and Facebook, when it comes to these two platforms, our churches are often getting flagged by music. But one of the things that I want to let everyone know before you chime in is that our licenses only cover the church's accounts. So if you create a personal account with the church's name on YouTube or on Facebook, it is not considered a business account, and therefore those protections for our licenses do not cover those. So I want you to be aware of that. So if you've created a personal account, and how do you know if it's a personal account that was created? The one way you know is that if you have friends, then you are a personal account. It's not a business account, because business accounts, people like the page. But if you have friends, then the church, you actually running a personal account, and therefore our licenses do not cover that. Now, I just wanted to chime in on this YouTube, Facebook, the dilemma of the flagging and all of those things that come up out of that.
Sure. I think I should back up a little bit. I want to talk about those licenses that you require everyone to get. So with the CCLI and CCS license, it allows you to use the music that is within their libraries. And so just because you have the license, you still have some due diligence to make sure the song you're wanting to use is a song that is covered. That's step one. Step two is if you're going to be streaming on a platform like Facebook or YouTube, they have their own rules and standards as far as how music can be used. Now, I know that both Facebook and YouTube have licenses with the 3 PROs that I mentioned, ASCAP, BMI, and CSAC, and they have their own agreements with them. So in some ways, it allows you to use music more freely. However, it means also that they don't have to honor the rights of the CCLI and CCS license. I reached out yesterday and I talked to representatives from both of those organizations, and they say, yeah, I mean, they will protect you, but Facebook may still flag you. YouTube may still flag you. At that point, the best thing to do would be to respond and let them know that you have a license and put the license information in there. But that's not an automatic that means that they're going to allow the music to be played, because these platforms have their own restrictions, their own agreements with these PROs that they have to honor. But I would say definitely respond when you get flagged.
Yeah, so I'm going to shift a little bit and go to a question. The question has come in. It says, Facebook organizational pages created for our school chapel services live stream from that page. So in other words, the school is live streaming from a organizational page that was created on Facebook, which the church branded as well. Is it covered under licenses?
So it can be, if you have a license listing the school, then the school is covered.
Yes. All right. So if whoever sent that question in, if you have a school connected to your church and your church has a license, then you're covered. If your school does things that are live streaming and those types of things, you need to contact our office to get a license as well. All right. So listen, we've got lots of questions coming in, and I'm really getting excited about this because there are some other aspects of music that we probably need to get a better understanding on. If I buy a track and I go to a church and I'm singing at this church and it's a beautiful song, people are moved, people are coming to Jesus. But I will tell you, if I was singing it, they would not be coming to Jesus. They would be running out of the church. But let's say it's a just, you spent the money, you bought the track, but the church is streaming it. They stream their service. Where are the pitfalls that come when it comes to that?
Well, my old answer pre this week would have been, when you buy a track, it gives you typically a license for public performance. It does not typically include a broadcast license. And this often confuses people. So they think they bought the track, they can use it however they want to, but you have to check the terms and conditions of the track that you've purchased. And if it's not clear, you need to contact the creator of the track or the publisher of the track, and they can tell you whether or not it covers broadcast. And these days, when our churches are streaming, that is considered broadcast. Now, I reached out to CCLI this week, and they have a new streaming license. It's a Streaming Plus license. And the really great thing about it is it covers background tracks. So now, as long as the track you're wanting to use, as long as that publisher has signed up with CCLI, it now allows you to use background tracks online as well. So I guess the takeaway is to contact the CCLI and CCS and find out whether the use that you're intending to use your track for is covered. That's always going to be my answer. My default answer is check, with the organization to see if there's permission for what you want to do.
Yeah. Now, I see a question. It's kind of a frustration that some of our churches have, and this is where they're trying to figure out what is their license number. And this is just for our churches, just to digress for a second, is that you can call CCLI and also CCS, and they can provide you with that information, because when you get your license, they give you the ability to create an account so that you can actually see the songs that you can actually use. Now, you've got to, if you've had this license for a very long time, you've got to, kind of go back and check with the treasurer, check with people to find that, because we have a master list with numbers on it, but that's not going to help you if you haven't created an account with these companies, because there is an auditing process that they like to see. I'm not sure how stringent they follow that, but to answer that question, contact them. I know it may be difficult, and I will tell you this: I don't work for CCLI and I work for CCS, but I did speak with them, and I can tell you this, that they are slammed. For the last year, they have been slammed. So if you're on the call for 30, 40 minutes waiting to get a representative, that's the world that's the world that we're in right now. So just be patient with them. Send them an email. Try to make sure you include the church's name as it appears in eAdventist, not what you may want to call your church, but what it appears in eAdventist. Now, just kind of shifting, you mentioned CCLI, CCS, but there's another one, Cvli. Tell us a little bit about the Cvli, which covers video.
So sure. So Cvli is affiliated with CCLI, and it covers videos, movies, movie clips, and it allows you to show those if you're a church during church service or even outside of church service, like let's say you want to have a social or something of that nature, you want to show a movie, it allows you to do that. Now, the limitation with CVLI licenses is that it really only applies to in-person use. So let's say that you want to show a video clip and a sermon that you're going to be airing over Facebook Live. That's going to get flagged because your CVLI license does not currently cover broadcast. There's one caveat where the Motion Picture Licensing Association has decided that because of this COVID time that we're in and everyone's doing things virtually, if you have a closed meeting, such as a closed Zoom meeting that requires a password so that you know the participants that will be joining, then you can still use your CVLI license for that. But the moment you start posting it on Facebook or on YouTube, you are infringing because your license doesn't cover that kind of use.
Now, I know everyone is probably like, man, there's a lot. Yes, there's a lot at stake, but there's also there's some great benefits of having the licenses that we offer for your churches. You can still do ministry. You have to think a little bit outside the box now that you're not in person. But you know, as Attorney Woods mentioned, close it off, and that means that, and correct me if I'm wrong, is if you close it off, you can still invite people from the public. They just have to have the code to get into it, and that is still considered closed.
Yeah, so from my understanding, you need to have some kind of some access, password or some sort, but you can still do a lot with that.
Yes. So let me just kind of throw a little nugget in here. Here's something for you. We always talk about getting contact information, connecting with people. Here's a way. If you do this and you close it off, you want to create a contact sheet so that people can sign up to watch it. Let's say you're showing Facing the Giants or something like that at your church, and you're doing it via logging in. You now have access to individuals' contact information to follow up after the movie, after the screening, after whatever you're showing. So there's another evangelistic way of connecting to people. You could put it out there, say, hey, you got to register. Follow up with that. So that's my pastor side. Just throw that out there for you guys, free of charge. As now, images. Google imaging. I mean, that is like an amazing platform. I mean, you put the word in there, and it gives you, and you could just download. You could choose the size you want. You can transparency backgrounds. Surely there's nothing wrong with Google imaging.
Surely there's nothing wrong with it. Yeah, Google Images are not public domain. If you take nothing else away from this talk, I'm hoping that you'll know that finding an image off of Google is never a safe thing to do. You are setting yourself up and your organization up for a copyright infringement claim. And the most recent example I can give of this is that there was a church, not in this conference, not in this union, that decided to upgrade or update their website. And they found some beautiful, wonderful images off of Google. And they decided to use those as the background for their church's page. Well, a couple of months later, they get these letters from this firm in Germany, of all places, saying, this is a famous photo. You didn't get permission. You owe us X thousands of dollars because when we license this kind of work out, this is a very famous a photographer. The church could have avoided all of this had they just gone and gotten a license from the beginning to use the image, or had they done some due diligence, maybe used a stock photo, maybe had someone go out, like it was the image of like a sunset against a mountain background. They could have had someone go outside and take the image, and that would have saved them money. But because they went and just found the image off of Google, they assumed that meant it was free to use. Sometimes people say, well, I found this image and there's no copyright information attached to it. Well, clearly that must be public domain, right? No, not at all, because under copyright law, I don't have to identify myself as the author. I don't have to put any kind of copyright notice on the work. The work is still copyright protected. I know that makes it very frustrating and confusing for you to find out who to seek permission from. But in those instances, I say, if you cannot identify the owner, if you can't find the copyright information, don't use the image, because it's just not worth the headache later on down the road. And the thing is, there are these rights management organizations, and they have technology to go through your website and to find the images that they own. So they will find you, they will find their image. And then they will send you the cease and desist letter.
Wow. There was a story, as a PR story about an image that was used years and years ago, and the person tried to track down the family, and the creator actually had passed years ago. Could not find anyone in the family. Seemed like they had passed years ago, and then it was basically said, well, there's no one alive that's connected to this image, so therefore it must be free domain. Well, they went ahead and used it, and sure enough, there was someone that was related down the road, 14th cousin, that ended up suing. And I guess it all boils down to it. If you didn't create it, if you didn't take it, and if you didn't buy it through a license, don't use it. Because it takes, we have to take all of these things, as this thing says behind me, take it personal. We have to take this personal, because it will affect us all if we have even one church with $150,000 infringement lawsuit against us. So we want to make sure that we're following, we're doing that which is right, because we don't want to get in that boat of using people. And it's just the right thing to do, really, because somebody put some hard work into that to make sure that it was something that they creative juices created. Now, as we think about videos, and as we think about music, and we think about photos, what are some of the things that you've seen churches outside of using these things or putting them in various places on their website? Are there any other places or any other ways in which churches get themselves in trouble when it comes to any of those mediums of infringement?
Sure. I mean, I think that the biggest ones that where we get the cease and desist letters happen to be with websites or things where there's an online presence, because those are the times that the copyright holder can see evidence of infringement. That being said, I like that you took it back to being personally responsible. Copyright is an intellectual property. So it's property, just like me having a physical CD in my hand. And none of us would go into a music shop and steal records. But when we go and use music without permission, it's the same thing. We're stealing someone's intellectual property. And the same thing with images. None of us would go to an art gallery and walk out with a portrait without paying for it first. But when we take images off of Google or other sites and don't give compensation or get, in very least, permission from the creator, that's essentially what we're doing. We're stealing. Sometimes we don't make that connection because it's so easy to do and it's so readily available online. But in essence, that is what's going on. So even though you might be able to get away with printing out flyers with copyright protected images on it, even though you've gotten away with it, ethically, it's still stealing. I would say that as Christians, it's the last thing we want to do. We do believe in the 10 commandments, and I'm pretty sure that thou shalt not steal is still one of those commandments. And so we have to hold ourselves accountable, even if the likelihood of getting caught is minimal.
Wow, that's interesting. It kind of brings there's a question that came in, and I think it's trending now, and I've noticed it more and more when people use music when they're sharing something. It says something like we do not have the rights for this music or video. I don't know if they put that in the post. It said, this is great video, great music, and then they put that in there. Can they still get in trouble for that?
Basically, when you say that, when someone says that, they're saying, I am willfully stealing. So you can no longer claim ignorance as a defense. And that $150,000 per infringing work, that's for willful infringement. So if you're putting that as a disclaimer, that does not get you off the hook. If anything, that's saying that you don't have permission, you chose not to get it, and you're going to use it anyway.
Wow. Now I see why attorneys are still in business, because I've seen that all over Facebook and all over YouTube with that disclaimer. When we're thinking about using fair use, a question has come in about a fair use. What is what is, well, first of all, what is fair use? To get a grasp of what that is, and then kind of give kind of an explanation of how that works.
Sure. So I don't like going into fair use because it's such a gray area, and I find that we like to rely on it without fully understanding what we're saying. So under the fair use doctrine in U.S. copyright statute, people have permission to use limited portions of a copyrighted work, including quotes, for purposes like commentary, criticism, news reporting, and scholarly reports or education. There are no hard and fast rules of what constitutes fair use and what doesn't. There are some guidelines, though. So courts will look at 4 factors to determine whether someone's use is considered fair or not. They look at the purpose and character of the use. So whether, and in particular, whether or not it's of a commercial nature or a nonprofit educational nature. They look at what kind of copyrighted work it is, because some copyrighted works are more creative than others. They look at how much of the work is being used, and they look at the effect on the marketplace. Is your use of the work without getting permission first, is that diminishing the copyright holder's ability to monetize their copyrighted work? The problem is that, I could say go through those factors, and if they all weigh in favor of fair use, you're fine. But by the time that a court's going to look at that, it means that you have been sued. It means you've had to hire an attorney. It means you have litigation costs. That is at minimum tens of thousands of dollars. I haven't seen litigation that's less than tens of thousands of dollars. So I say that unless you're going to do a very thorough analysis of each time you want to claim fair use, I would stay away from using it, because there's no such thing as like a 1-minute rule or 30-second rule for clips of videos. There's no such thing as a black and white rule as far as how much of a quotation constitutes fair use and then at what point it becomes infringing. The courts are all over the place on this. So it's a, people can claim it sometimes, but it's a very gray area.
Yeah, I just want to reiterate what you said. Fair use for criticism, comments, news reporting, teaching, scholarly work. So we have to be very careful. If it does not fall in those lines, then we need to stay far away from those things.
Yeah.
So fair use is difficult at best, but it is something that often is used. There was another question. Let me see if I could read it from here. It says that. So what is the recommendation for those of us who have PowerPoints for years in many places? Oh, wow. Okay. And it's recorded in different times. Wow. So they've got, my understanding is that they have a PowerPoint that they've used for years. It was recorded here, recorded there. It's in, a church in, another state, another country, maybe using it. What then?
So here's the advice that I give. I think for every church, you should go through an auditing process at this point and clean out your online presence. If there are any images in PowerPoints or images online that you don't have a clear understanding of where the rights came from to use those, get rid of them, delete them. And that doesn't mean, it needs to be not findable anymore. It needs to be completely deleted, because even if you can't find it, if the search engine can find it, it will still constitute infringement. So I would say, go through all of the old resources that you have, make sure that you have the necessary permissions and start fresh. If material is extremely old anyway, it might be stale anyway. So it might be time to get rid of it for other reasons. But at a very minimum, from a copyright liability standpoint, I would say only keep things online that you have full rights to use.
Yeah. There are some great resources that people are putting in the chat for pictures. There's also, we use stock videos, stock music, but we actually purchase a license from Artlist and ArtGrid. Those are two affordable annual licenses that we use, and every song that we download has a license with it. Every single song. And we have downloaded hundreds of songs for our videos and things like that. We've also downloaded many stock videos that they offer. And they're all licensed and you can use them without any issue. We've had no issues whatsoever. We do know that when we upload our music to or our video to YouTube, it does say that there is copyrighted information in that video, but we know that we're covered because we have the permission from the artist to actually use that, and we have that to back up. So that's Artlist and Art Grid, and we can share that information with you. There's some other things that are out there, some places we can get stock photos. But the one thing I will say is this: please, if you think about the cost versus the discomfort of paying for a subscription, think about for $500 a year, you can download as much music as you want. Or for $150,000, you will be hit in an infringement. So just think about that for a second. We want you to, take it personal, do what's right, but we also want to make sure that we provide you with resources to where you can find, videos, music that you could use. Now, one thing I will ask Attorney Woods is, when it comes to CCLI and the CCS license and the CVLI license, all of them function slightly different. And we often are told, why do I need this one? Why do I need that one? I only do this one. Can you just kind of give us a better understanding of how they all work and how they kind of work together and how they're different?
Sure. So I think I touched on the CVLI license. That is the license that covers use of video, movies. And so that's kind of what distinguishes that license.
Well, let me just say this real quick. The videos are not videos, just random videos that you grab from somewhere. I just want to let people
know. These are legally purchased videos. So the license is very explicit, and it says that the video that you are showing has to have been purchased legally for the license to apply. And that leads to another thing I should state. No matter, you gave some good examples of some places to purchase like stock photos and stock music. You still are responsible for reading the terms and conditions of use, because the moment you step outside of those terms and conditions, you are infringing. So that's just, no matter what you're going to be using. So CCLI, they have two main licenses. They have the copyright license. And what that covers is that when you want to display the lyrics for congregational singing, that's what the CCLI license will cover. It covers being able to display the lyrics or include them in a bulletin. Outside of having that license, you can't do that for any copyright protected work. CCLI also has a streaming license. And as I mentioned, they now have a Streaming Plus license, which allows you to stream the musical portions of your worship service online. CCS has a slightly different license. They offer a performance license for performances that are outside of religious service. So this would include schools, because classroom settings aren't considered religious services. It would cover your church social or other events that aren't religious in nature. So like you're covered under the exemption for church service, for vespers, for prayer meeting. But outside of those scenarios, you really need to have a CCS license if you're going to be using music. CCS also has a streaming license. I think it's called Worshipcast, but I may be wrong on that, which also allows you to stream music. Now, one limitation with that license is that you can stream pre-recorded music, but it can only be music that you have recorded or someone in your church has recorded. So you can't go and take a YouTube video of a performance and stream it because you did not record that musical performance. So that's one of those limitations there. But both CCLI and CCS have certain terms and conditions, but they both offer a streaming option, which is beneficial.
What about background music apps that are used for video?
Right. So there's also, I guess there's I'm not sure if you're talking about like audio network, where they have like background music or soundtrack music that you can use. But there are places you can get background music, because typically if you're going to use background music that's going to be used in conjunction with video, what they're giving you is a sync license. And like I said, that's a different kind of license. For both the CCLI and the CCS streaming license, you can't stream music with visual components other than the person who is singing or performing the music in question. So again, you have to know the terms and limitations of these licenses. And you have to look at the library of the available music and make sure that the song you're wanting to use is in fact covered by one of those organizations.
Absolutely, absolutely. And that's why it is important that you set up that account to go in to see what's available for you to use. We're also going to add, we have an innovation page that we launched back in, I believe, April. I think it was April, where we put a lot of innovations to help us get through this COVID period. But it looks like it's going to, it's helped us provide resources. So if you go to, I believe it's Texas Conference, texasadventist.org/innovation, you'll be able to see the websites that we'll put up there. And there's also some great information, great resources that you can find there. Another question I have for you is, as we kind of wind this down, the other question is, where was it? If we play music live, will we be okay? And I'm wondering if they mean perform it live or play it live. I'm not sure exactly, but maybe you can answer both of them.
Sure. So if you're playing it live, and again, it's a song that's included in the library of your CCLI or CCS license, then that should be fine. If you're talking about playing a recording, but playing that live, then it depends on, that should be okay as well, but I would check the license terms. I know that for CCLI Streaming Plus, it's okay. But again, I would just check. And these things are being updated because we are in this new world. And so these organizations are trying to make sure that churches are covered. And so they're trying to give more permissions, not less. But it should be fairly easy to go onto the website and find out. But definitely if it's a live performance and the song is in the repertoire, then that should be fine.
What about, should churches, stream YouTube music videos in the church? So in other words, they have we got this song by Israel Houghton, and you want to play that for your appeal, and there's no one singing, so you just put it up on the screen and play it, but it's streaming live.
So this comes down to what kind of license you have. Again, this week, I would have said, nope, you can't do it. The licenses that I'm aware of don't cover it. However, now with the CCLI Streaming Plus license, you can use the actual master recording. So if you wanted to use Israel's, his version of I Am a Friend of God, the one that he recorded, you can do that. Now you can't use it with like visual works in the background because again, you'll need a sync license for that. But you can use that on its own as like music in between service or as filler music. And that should be fine to do if you have the proper license in place. Okay. I do want to make one quick plug that there are also a ton of resources on the NAD's social media big data website. And so I do want to make everyone aware of that the website is sdadata.org. It has information as far as streaming. It has a fuller copyright presentation that I've done. It also has like a quick tips fact sheet. But I just wanted to make that plug because it's a great place to get resources and it has contact information for myself as well on there.
All right. Thank you. Thank you. Just a couple more questions. I think you touched on this one already, but someone said, can we live stream Adventist hymns?
So it depends on the hymn. If it's a hymn that is in public domain, then yep, you can do whatever you want to do with it. You can change the lyrics. You can make put two hymns together and make up your own song out of it. And you have a lot of options. If it is a song that is protected by copyright, you have to see if it's covered under one of like the organization CCLI or CCS, or get some other form of permission before you can do that.
Okay, so so if it's pre-1924.
Yeah. But a lot of the hymns are. So like, let's say you want to make a mashup of "'Tis So Sweet to Trust in Jesus" and "Amazing Grace." Go for it.
All
You
right.
have the right to do that.
Okay. All right. Let's see. I know there's another one that, oh, okay. Can we safely use material? Oh, this is a good question. Can we safely use material produced by Adventist conference, unions, or GC, etc.? So Adventist artists, can we steal Adventist artists' music without them getting mad at us because we're all one big happy family?
So I want to talk about two areas where that becomes problematic. First off, just because the artist or creator is Adventist, it does not mean that they've granted it to every other Adventist to use. So you need to still get permission. But let's say that even the GC, you look at the Adventist review and you find images there you really want to use, or an article you really want to use, and you're like, well, this is in the review. Clearly I can use it. No, not necessarily, because the Adventist Review has certain permissions that they got for their use of the article or their use of the picture. They might have used a stock image, and their use is limited. So you can't assume that you can then reuse the image. People have gotten in trouble for that in the past. That example in particular, where a ministry found another ministry's image on their website and decided to reuse it because they said we're one big happy family. The image owner said, no, not so fast. You owe me money now. So the best thing to do is, if you find something from the conference or union or division or the GC that you would like to use or reuse, contact us or contact them. And they can then tell you, oh yeah, we own that, you can use it. Or no, we have a license for that. Here's who to contact to get permission.
Good. Thank you so much. We are just about out of time. We want to just point you to our communication email, communication at txsda.org. If you have other questions you want to have answered, or you want to get in touch with Attorney Woods for maybe a presentation for your church or any of those things, feel free to reach out to us. We will be happy to share that information with you. We did record this segment, and we are going to archive it, put it on our YouTube page, and we're going to share so you can we're giving you permission to share this with your church. And if you have any other questions, please contact us at communication@txsda.org. Attorney Woods, thank you so much for sharing. This has been awesome. This is one of the big questions that we have. We know that we're probably going to get more questions about this, but thank you so much for making it plain, laying it out for us so that we can understand it a lot better.
My pleasure. Thank you for having me.
Hey, Texas Conference, and all of those that are watching, thank you for joining us. May God bless you. May God keep you. And let's have a word of prayer as we close out. Father in heaven, Lord, we are so thankful for this opportunity for us to talk with Attorney Woods. And Lord, just thank you for the work that she's doing at the General Conference and trying to keep us ethically sound, Lord. We know that it is up to us to do our part. But Lord, it is imperative that we follow what you have laid out before us, Lord, and so that our witness will not be tainted by those things that we end up doing. Lord, we just ask that you would bless her, be with her family, Lord, be with all of those that are watching, be with the churches, the pastors, the teachers, and all of our schools. And Lord, just bless everyone as we continue to go through this difficult time. But Lord, let us also be ready for your soon return. We pray these things in your name. Amen. Thank you once again, everyone, for joining us. May God bless you, and we hope that you will join us again for another segment from Texas Conference Comms PR.